All right, welcome back. I've got one for you today. I, oof, I'd say I've got a fun one for you today, but I've got one for you today. That's the best I can do. I've got one for you today, and I say that because, in the words of Law Talk with Mike, it just got worse. It just got worse. So this morning we're returning to Las Vegas for more DeCastro versus Las Vegas Metropolitan Police Department. And and today's going to be a double header. This afternoon I'm going to do an update on the Schofield versus Giard case. I know I keep plugging it, but it gets a fraction of the views that this nonsense does. It's a much more interesting case, so go watch that. But so, like I said, we're in Vegas, and last time we were here, funny enough, just yesterday, we were discussing the judge's order denying Delete Lawz motion for a preliminary injunction. He was trying to get a stay in the state criminal case, which he didn't get. And so, an update on the state criminal case. I I haven't looked. Actually, our Nevada judges was there. It. I don't know if it's up yet or if they're even going to put it up since Delete Lawz wasn't there. His lawyer was, which in Nevada is allowed for misdemeanor arraignments. So, I don't know if it's worth watching or not. Uh, from I got my update basically. Paul Berry, thank you very much, on the Chili Watch Discord, and he was there in person and immediately sent out an update. Basically, the judge asked Delete Law's lawyer, "Have you received a plea deal?" He says, "Yes, my client wants to set it for trial." I'm annoyed at the judge because his next question was basically, why isn't he taking the plea deal? And that's wildly inappropriate because, number one, he's asking the lawyer to divulge client communications. That's not right. But also, if a judge asked me, why isn't your client taking the plea deal? I First off, I'd have steam coming out of my ears. But second, my response would be, because my client is innocent until proven guilty, and he has a constitutional right to a trial. That's all that needs to be said. So, you know, we've seen the video, we know the evidence basically, but he still has a right to a trial. So, hey, go to trial. That's fine. Um, but that puts us back into federal court, though. Uh, now that we have the update on the criminal case, because we had two things happen today. And the first was Delete Law's motion for reconsideration on the preliminary injunction, which he just can't take no for an answer. That's probably why he's received so many restraining orders, is my guess. But then, like I said, it gets worse, and we received a motion from a Jason Jensen, for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus. And That's insane, to put it bluntly, and it's going to require more shock horror education. So you might learn something today. I'm sorry. But with that, let's jump straight into the motion to reconsider. And it's titled Emergency Motion to Reconsider Motion for Preliminary Injunction to Stay State Proceedings. And his phone still doesn't usually work. Sorry. Plaintiff Jose de Castro hereby moves this honorable court to hear his emergency motion pursuant to local rules 6-1D and Federal Rule of Civil Procedure 6C1C to reconsider plaintiff's motion to stay at ECF number 18, pursuant to 42 USC section 1983 and Federal Rule of Civil Procedure 65. Motion to stay the state criminal proceedings on the claims in this action that are brought under the case number. The first hearing of which is to be held at 8 a.m. on June 13th, 2023 at the Justice Court, Las Vegas Township, Clark County, Nevada. It's already been heard, so this is moot, at least as far as that goes. This emergency motion is made because of the timing of the criminal action on June 13th, 2023, that will chill plaintiff's rights. Plaintiff had expected his internal affairs complaint to have been completed, but the LVMPD's own delays have led us here. So by the time he submitted this motion for reconsideration, he already knew that internal affairs had closed his complaint with no action, because it's ridiculous. But the motion for reconsideration is made under Federal Rule of Civil Procedure sections 59E and 60A1, requesting consideration and identifying error in the court's order at ECF number 19. Identifying error. In support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. Argument. This court has said that plaintiff does not explain the nature of the first hearing on June 13th, 2023, or how that hearing could impact his claims in this case. The citation did not say what the first hearing is, and so plaintiff could only guess. Or he could have, looked at the court calendar, saw that it's scheduled as a first appearance or scheduled as an arraignment or whatever. He could have called the court and said, hey, what's this hearing I have scheduled? He could have hired an attorney earlier and said, hey, what's this hearing? Those are all things he could have done instead of guessing. Since they're misdemeanor offenses, which may not grant a probable cause hearing or a grand jury, plaintiff imagines that worst case, the first hearing will be an arraignment. That's the worst case scenario, an arraignment. He needs federal court intervention over worst case, an arraignment. An arraignment where all that happens is the court reads him his charges and asks guilty or not guilty. That's his imagined worst case scenario. An arraignment resulting in charges will result in defendants making a motion to stay these proceedings, as they have promised under Younger doctrine. Well, yeah, because that's how it works. But I can only guess because I haven't read this. He says an arraignment resulting in charges will result in defendants making a motion to stay these proceedings as they have promised under the Younger Doctrine. So he needs that stayed to keep this going, even though the way it works is the other way around. But hey, this is, check out this life hack. You can stop criminal proceedings by doing this. Stop criminal proceedings in 3 easy steps. The court has cited Younger versus Harris, which does clearly state that a federal court should only enjoin a pending, italics, pending state criminal proceeding only under exceptional circumstances. However, in italics, the criminal action in the instant action is not pending. The U.S. Supreme Court has held that a preliminary injunction is not held to the strict Younger standard if charges have not yet been filed, citing Doran versus Salem Inn from the Supreme Court in 75, Woolley v. Maynard from 77, Hicks versus Miranda from 75, Huffman versus Pursue in 75, and Hawaii Housing Authority from 84, all Supreme Court cases. Criminal action is pending. Otherwise, I know this is a difficult concept, but if criminal charges are not pending, you wouldn't have criminal court this morning or yesterday morning when you see this. So criminal charges were already pending. That they don't start at arraignment. Additionally, the U.S. Supreme Court has said that one is entitled to a preliminary injunction when the question is a matter of civil rights, as it is in the instant action, citing Woolley. In Younger, the court recognized that principles of judicial economy, as well as proper state-federal relations, preclude federal courts from exercising equitable jurisdiction to enjoin ongoing state prosecutions. However, when a genuine threat of prosecution exists, a litigant is entitled to resort to a federal forum to seek redress for an alleged deprivation of rights. The problem is, remember yesterday's video. He's missing a step here. It's only if the state proceeding doesn't give you the opportunity to make the constitutional challenge. He can make a constitutional challenge in the state proceeding here. So Younger applies. No stay. He can use a defense in the criminal proceeding. This was an illegal arrest. I was filming. I had the right to film. They violated my rights. Therefore, I'm innocent. The jury doesn't have to believe him, but he can make that argument in the state proceeding. But reading on. Although death in a corrupt jail would make it impossible to raise constitutional challenges in the state case, plaintiff is only required to raise the threat of prosecution chilling his First Amendment rights, which would occur if plaintiff is in jail, which plaintiff did raise. As a hypothetical. I'm like, he's so dumb. This court has also said that plaintiff has given no reason to suggest that he will be jailed. In the motion, page 1, lines 7 through 8, the offenses are listed, which are misdemeanors, which carry a maximum jail time of 6 months. Additionally, there is no guarantee of bail before trial. He really loves putting the cart before the horse. This is a constant sovereign citizen problem. Yes, the misdemeanors carry a maximum jail time of 6 months, which you're not going to receive at the arraignment. And I mean, even if you plead guilty, you're not going to receive the maximum 6 months at arraignment because, hey, you're going to get the best deal possible at the arraignment, most likely. And there's no guarantee of bail before trial. Of course, there is. There are very limited circumstances where you can be denied bail. And those are, if you basically, if the crime is severe enough, we're talking like, Brian Koberger, if you have the ability and a high likelihood of fleeing, like to a non-extraditable country. So we're talking huge money, but even then, they'll just a huge bail proportional to your resources to make it painful to flee if you forfeit that bail. Or if you can have your bail revoked and then denied. So basically, if he's given bail conditions at the arraignment and then he violates those conditions at the violation hearing, it can be revoked and he can be held until trial. And even then, chances are they're just going to send it to the next judge up and the trial judge and say, hey, we'll let you decide bail. Conclusion. Plaintiff prays for this court, now that it knows that charges are not pending, reconsider plaintiff's motion for a preliminary injunction under the proper law, which stems from and is properly cited under Dombrowski versus Pfister from the Supreme Court in 1965, which was cited in plaintiff's original motion. Plaintiff discussed these later decisions with defendants in his meet and confer process. If they had raised Younger in opposition, plaintiff would have replied in the same way as here. They did raise Younger. They didn't say Younger, but they did raise Younger when they said, we saw his meet and confer statement where he said basically the same thing he said up here. An arraignment resulting in charges will result in defendants making a motion to stay these proceedings, as they have promised under Younger doctrine. So they didn't say Younger, but they said they'd do it in the meet and confer. But if they had raised Younger in opposition at the meet and confer, he would have argued it. But he did argue it wrongly in his meet and confer declaration, where he argued it in the wrong direction. It's just, it would be unbelievable if we didn't already know he's this stupid. And I mean, the reality is, if charges were not pending, as he's trying to argue, even though, as I've said, charges obviously were pending, otherwise he wouldn't have had a court date. But if charges were not pending, there would be no case or controversy, and therefore it would be moot, so he couldn't get a injunction anyway, because courts can't rule on something that's moot. It just doesn't work. It's unconstitutional. You'd think a 20-year constitutional law scholar would understand that. Needless to say, this time the court probably will just stamp it denied. But since today's a doubleheader, let's quickly move on. And here we have, still in the United States District Court for the District of Nevada, in the same DeCastro versus LVMPD case, we have the motion to intervene, which, spoiler alert, is not going to work. And Jansen, it says, jury trial demanded by right and privilege. And it's Jensen's, oh, I thought it had said Jansen. Oh, it's Jensen. That's fine. So Jensen's motion for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus. Comes now, intervener plaintiff Jason A. Jensen, under Federal Rule of Civil Procedure 20, in joinder to plaintiff's motion to stay Nevada State case, case number, at the Justice Court, Las Vegas Township, Clark County, Nevada. Jensen furthers said motion with petition for extraordinary writ of mandamus under Federal Rule of Civil Procedure 21 and 28 U.S. Code Section 1651, the All Writs Act. Jensen propounds the following. And we'll take a look at Rule 20 and Rule 24 in a minute. And then what? Just, I don't have it pulled up, but let's take a peek. Rule 21 is misjoinder and non-joinder of parties, which is irrelevant. Present in the defense of Mr. DeCastro's amended complaint, the state of Nevada and its political subdivisions have orchestrated a policy with the express intent to create recording and talking to a roadside traffic stop detainee criminal under the legal theory of obstruction of an officer's duties. They haven't tried to make recording a criminal offense. They said, we're fine with you recording. You have to back up and stop interfering by speaking to my detainee. In the state case, Mr. DeCastro is charged with the following crimes. A, false statement to / obstruct public official, 52.312 under NRS 197.190, which is a misdemeanor. And B, resist public officer under NRS 199.280.3, which is a misdemeanor. Mr. DeCastro, by apparent intent of design of the state's policy, cannot mount a defense based on the rights of a traffic stop detainee's Miranda rights and the principles of Berkemer versus McCarty from the Supreme Court in 1984. what does that even mean? I mean, I'm loath to say it, but this guy makes Delete Lawz legal writings look good by comparison. And his are bad. But this guy is worse. And apparently, I didn't watch it. I don't tend to enjoy huge panel shows, but apparently he went on Welsh News Network tonight and he's nuts and probably a sovereign citizen follower of Delete Lawz and just oof. But he's I really don't know what he's trying to say here. So Delete Lawz by design of the state's policy. So basically he's saying the state won't let Delete Lawz defend himself on these charges based on the rights of the traffic stop detainee. So, and I assume he means her Miranda rights. But how would her Miranda rights or her invoking her Miranda rights or anything to do with her have anything to do with what defenses Delete Lawz can put forward? It just it doesn't work that way. Mr. Jensen cannot motion to intervene in a criminal matter at state court. In its order, the district court summarily denied the press's application based on the proposition that Nevada law does not permit intervention in criminal cases, citing Stevens Media LLC versus 8th Judicial District Court from Nevada in 2009. So that makes sense. You can't intervene in a state or in a criminal proceeding. Now, I will explain intervening more fully after this document, but basically, very briefly, it's as if you're stepping into the litigant's shoes to argue their points for them. And it makes sense that you couldn't intervene for a criminal defendant because it's the criminal defendant that will go to jail if they lose, not the intervener. This is the exact mechanism that the state is using the denial of two class persons' rights, namely Mr. DeCastro's rights to record, converse, and attempt to contract for YouTube videos by alleging obstruction and interference, whereas the defendant cannot claim the rights of the motorist subject to the traffic stop. In concurrence, the driver does not have standing to assert the rights of the videographer. In this way, both persons' rights are negated, while neither person has standing to challenge the policy. What? What? That doesn't make sense. And besides which, if what I think he's trying to get at here, number one, I don't know why the driver would want to be advocating for Delete Lawz here. They have nothing to do with each other except he interfered on her traffic stop. But if that negated her rights, and so someone needs to intervene, it would be her that would intervene, not some random person. Wherefore, Jensen requests joinder to the plaintiff's motion to stay state proceedings, and Jensen requests a writ of mandamus of all Nevada officers, John Does 1 through 50, from prosecuting a criminal matter upon Jose de Castro or any person by charge of obstruction by exercising the right granted to the public in conjunction with the traffic stop detainee's Miranda rights, with the purpose of negating Miranda rights by presenting a case that cannot be defended as apparent by intent of design of policy and actions. Sincerely and respectfully submitted, signed by Jason A. Jensen. Certificate of service, he's served it by ECF. But so a writ of mandamus, basically, you can look at it as a writ of mandate. It's the court saying, do this or don't do this. It's saying, do something. And he wants to stop them. He wants a writ of mandamus from the federal district court saying Nevada may not charge anyone with obstruction if they're exercising the right granted to the public in conjunction with the traffic stop detainee's Miranda rights. But that's a non sequitur. Delete Lawz didn't do anything at all that had anything to do with the traffic stop detainee's Miranda rights. Nothing at all. So, because this is a non sequitur, it doesn't work. I mean, even if it weren't a non sequitur, that's not a right given, so it doesn't work. But this is just absolutely insane. And so let's look at the rules, though, because as threatened, we've got to be a little educational. So we often see sovereign citizens, when they're interacting with police, saying, I refuse to give my license because that creates joinder with you, and I refuse to joinder with you. And that's not joinder. Joinder is not a contractual term, but joinder is part of the federal rules of civil procedure. And it's basically, you can bring multiple parties. You know, if my rights are violated and Delete Lawz rights were violated under a sufficiently similar series of facts and events, we could jointly combine as plaintiffs to sue the state. And that would be a permissive joinder of parties. So let's read the rule. Rule 20, permissive joinder of parties. A, persons who may join or be joined. 1, plaintiffs. Persons may join in one action as plaintiffs if A, they assert any right to relief jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and B, any question of law or fact common to all plaintiffs will arise in the action. 2, defendants. Persons, as well as a vessel, cargo, or other property subject to admiralty process in rem may be joined in one action as defendants if A, any right to relief is asserted against them jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and B, any question of law or fact common to all defendants will arise in the action. 3. Extent of relief. Neither a plaintiff nor a defendant need be interested in obtaining or defending against all the relief demanded. The court may grant judgment to one or more plaintiffs according to their rights and against one or more defendants according to their liabilities. B. Protective measures. The court may issue orders, including an order for separate trials, to protect a party against embarrassment, delay, expense, or other prejudice that arises from including a person against whom the party asserts no claim and who asserts no claim against the property. So basically, A1 is what's relevant here. Plaintiffs, persons made in one action as a plaintiff, if they assert any right to relief jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences. So this Jensen person cannot have permissive joinder to be a co-plaintiff in this motion for preliminary injunction because he has not asserted any set of facts, especially not facts arising out of the same transaction, occurrence, or series of transactions or occurrences, or any question of law or fact common to Delete Lawz. So he's just a rando trying to get in, and he can't be a plaintiff in this. And then he mentions 21, which is misjoinder and non-joinder of parties. Let's take a peek at that. If it wants to load. So Rule 21, misjoinder and non-joinder of parties. Misjoinder of parties is not a ground for dismissing an action. On motion or on its own, the court may at any time, on just terms, add or drop a party. The court may also sever any claim against a party. Well, but no one was misjoined, or the non-joinder would be a needed party was not joined. So this whole section is irrelevant, even though he included it. So, but then let's take a look at Rule 24, intervention. So there's intervention of right, meaning by law you can intervene, but then there's permissive intervention, which is what this would be. But just the same, let's look at both. So A, intervention of right. On timely motion, the court must permit anyone to intervene who, 1, is given an unconditional right to intervene by a federal statute, or 2, claims an interest relating to the property or transaction that is the subject of the action, and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interest, unless existing parties adequately represent that interest. And then we have B, permissive intervention, which is what this would be. 1, in general, on timely motion, the court may permit anyone to intervene who, A, is given a conditional right to intervene by a federal statute, or B, has a claim or defense that shares with the main action a common question of law or fact. 2, by a government officer or agency. On timely motion, the court may permit a federal or state governmental officer or agency to intervene if a party's claim or defense is based on a statute or executive order administered by the officer or agency, or B, any regulation, order, requirement, or agreement issued or made under the statute or executive order. 3, delay or prejudice. In exercising its discretion, the court must consider whether the intervention will unduly delay or prejudice the adjudication of the original party's rights. And then finally, Section C, notice and pleading required. A motion to intervene must be served on the parties as provided in Rule 5. The motion must state the grounds for intervention and be accompanied by a pleading that sets out the claims or defenses for which intervention is sought. So, like I said, this would be permissive intervention, but it's not going to be allowed. And let's scroll down into the advisory notes to see why. So, first off, the right to intervene is given by the following and similar statutes. And those are Title 28 USC Section 45A. In 1937, it was 45A. Now 2323. Special attorneys' participation by interstate commerce commissions, intervention in certain cases under interstate commerce laws. That doesn't apply here. The current Section 2322, suits to be against United States, intervention by United States. That doesn't apply here. Current Section 2403, intervention by United States, constitutionality of federal statute. Well, this isn't a federal statute. And then Title 40 USC, currently Section 3144, bonds of contractors for public buildings or works, rights of persons furnishing labor and materials. That doesn't apply here. So that's not an exhaustive list, but it gives you the idea of the sorts of statutes that provide a right of intervention that can't be denied. But let's scroll down. So this paragraph right here is a good example of a situation where intervention should be allowed. So it says the general purpose of original Rule 24A2 was to entitle an absentee purportedly represented by a party to intervene in the action if he could establish with fair probability that the representation was inadequate. Thus, where an action is being prosecuted or defended by a trustee, a beneficiary of the trust should have a right to intervene if he can show that the trustee's representation of his interest probably is inadequate. Similarly, a member of a class should have the right to intervene in a class action if he can show the inadequacy of the representation of his interest by the representative parties before the court. So that's where intervention should be allowed. So let's say my parents have all their assets in a revocable living trust. So their house is owned by the trust. And when they die many years from now, my siblings, that there's a corporate trustee that is trying to sell the house for pennies on the dollar. And hey, the trustee is working on behalf of the trust, which owns the house. But my siblings and I, we're the beneficiaries of the trust. We get the proceeds of it, but it's the trustee's job to sell it. So if he's trying to sell the house for pennies on the dollar, well, we and it's you know the I forgot to set up part of the hypothetical. It would have to already be in litigation, and let's say the other trustee is suing two trustees, one suing the other, trying to, one trustee is trying to sell for pennies on the dollar, the other trustee is trying to sell for merely half price instead of pennies. Well, my siblings and I, we'd have the right to intervene, even though we're not trustees, but as beneficiaries, and say, hey, we want full price for the house. And the judge should grant that. And I think that's all the notes I wanted to look at there. But so when I think of intervention, the case I think of is Hollingsworth versus Perry. And the reason it's the case I think of is because it's the one we discussed in my law school civil procedure class, because it had just barely been decided by the Supreme Court. So the basic background of this case. So this case, I'm looking at the Wikipedia page for it, but trust me, I've read the case. It's just easier off of Wikipedia because there's a whole procedural history of it. So basically, the case began in 2009 when a person named Perry, last name Perry, sued in California to overturn Proposition 8. Proposition 8, of course, being the ballot initiative that banned gay marriage in California. So, in the U.S. District Court for the Northern District of California, they sued first Arnold Schwarzenegger, so it started as Perry versus Schwarzenegger, and then it turned into Perry versus Jerry Brown because, they switched governors and you sue the governor if you're suing the state. And in the district court, Perry won. So basically, the district court said, yeah, Proposition 8 is unconstitutional. It violates people's rights. It's overturned. Gay marriage for everyone, if they want it. Well, Governor Brown then refused to appeal. They wouldn't appeal. They said, we think this proposition was BS. We don't like it. So we're not going to defend it. We are not going to appeal it. So Hollingsworth, Dennis Hollingsworth, was the organizer for Proposition 8. So he intervened and said, well, if the state of California is not going to appeal this and defend this, I am going to. And he took it all the way to the Supreme Court. Now, the Supreme Court, as you may know, they love decisions on technicalities. They love procedural decisions instead of deciding a case on its merits. So they were not ready to decide a case on the merits for gay marriage. They waited for that until 2015 with Obergefell. So this was decided on the technicality. Basically, what they decided, reading the holding right here, after lower courts ruled that California's ban on same-sex marriage was an unconstitutional violation of the right to equal protection under the law, the Supreme Court ruled that same-sex marriage opponents did not have standing to intervene, as they could not demonstrate that they were harmed by the decision. So this was basically, it was ostensibly brought to the Supreme Court by Hollingsworth saying gay marriage bad. And the Supreme Court said, yeah, but it doesn't harm you, so you had no right to even bring it to us. Case dismissed. Well, case, the holding from the trial court was affirmed because it wasn't appealed by the right person. So this is what I think of when I think of intervention, even though it's an example of intervention not working. So I hope that was at least a little bit clear. I realize the law can be a very complicated subject. So hopefully the water is a little bit less muddy. Needless to say, Mr. Jensen has suffered no injury. He won't be allowed to intervene. Expect a swift denial and, of course, a equally swift denial of Delete Lawz attempt to get the court to re-examine his motion for a preliminary injunction. And with that, I'll leave you guys here for this one for today. I'm sure I'll be back very soon for more of Delete Lawz madness, especially since, hey, Google's reply brief is due tomorrow, the 15th, in Massachusetts. So at the very least, we should have that very soon. But as I said, today is a doubleheader. So join me this afternoon when we go up to Idaho. Funny how both of today's cases border Utah. Well, and Idaho and Nevada border each other, of course, but I'm in Utah. So join me this afternoon for more TikTok psychic nonsense up in Idaho. Do all the YouTubey things on your way out. Like, share, subscribe, and thanks for joining me. Bye-bye.